All right, good morning, everyone. Thank you. I'm loving this training room in the last couple of weeks, seeing so many faces that I don't normally see. So very exciting to have it, very blessed to have it. We're welcoming Catherine and Thomas today. They're kind of talk to us about commercial real estate. Give us a little intro to commercial real estate. So very exciting since we want to try to get into more commercial. I know a lot of you have been asking. So thank you very much for coming today. I'll let you guys have the floor. I'm just going to share your presentation here.
So, good morning, everybody. Before we get into real estate, I think we should probably tell you a little bit about our firm. So, Thomas Efraim is a combination of Leon Efraim Professional Corporation and the law office of David Thomas. David Thomas was practicing in the area of real estate in Oshawa, but he did real estate pretty much across the province. He acts for several charitable organizations, religious organizations that own a fair bit of real estate. And he was always considered someone who would be a specialist in the area of problematic title issues and that kind of thing. My area is the area of corporate finance, particularly in the area of real estate. So developers that raise money often seek me out to use me to help them structure their deals and raise the money. People who are buying multifamily residential or even industrial commercial seek me out to help them raise money to close their transactions and bring in their partners and manage all that kind of stuff. And I've been practicing for about 25 years. And so along the way, I've learned a lot of stuff. And Kathy, my associate at Thomas Efraim, has been working in the area of real estate for like almost 10 years. But, right down in the trenches, doing all the registrations, learning about the Planning Act and managing all those kinds of things. So when it comes to things like due diligence or title issues or those kinds of things, if Dave's not around, I rely on Kathy. She knows what she's talking about. And so she's going to deal with the commercial presentation. I'm going to jump in once in a while when I think that there's something that might be of interest to you guys that I might be able to add to it.
Yeah, so. Okay. Okay, so basically we're called to discuss about commercial real estate. I know with some real estate agents, it's a different field, right? Residential real estate is like what we call, sometimes we do like a cookie cutter deal, because that one you can close your eyes and you can prepare an agreement of purchase and sale. But sometimes on a commercial, it's completely different because it depends on the commercial property that your client is buying or the commercial property that your client is selling. So there's a bunch of things. And we will be giving you an bird's eye view of what the commercial real estate is. So what is commercial real estate? So basically, you can say that it's a commercial property when it's basically used for business or income generating purposes, right? What are the examples of those? Like plaza, commercial buildings, medical buildings, restaurants, cafes, like if you want to buy like a bar, those are the commercial properties. Okay, categories. What I've told you: office space, industrial use, multifamily, multi-residential units. Let me coach you on that. Okay, because with multi-residential units, for title insurance purposes, a residential property is if it's 6 units. More than 6, it's considered commercial. So you need to understand which one you're selling or which one you're buying, because I've been seeing sometimes a multi-residential property with 7-plex, 8-plex. So that one, you should be using a commercial OREA form. Be careful with that because it's not considered a residential anymore. Okay. Retails, hotels, resorts, restaurants, healthcare facilities, gasoline station, etc. Key concepts like asset versus real estate or a combination of both, right? We were going to be discussing that. Commercial leases, which Leon is going to be discussing later on, due diligence, and HST. In a commercial property, those are the 4 things that you need to look for. What is asset and what is a real estate, or a combination of both. Asset purchase is basically, for example, you're buying a business, a restaurant business, but you're not buying the real estate portion itself. That's what we call an asset purchase, right? Leon has been closing a bunch of those. Like it can be any type of business, restaurant, bars, what do you call that? He even has the, what do you call that, Leon?
So a lot of franchisors or a lot of franchisees use our office. So just to jump in here, when it comes to an asset purchase, typically you're looking for an assignment of lease from the landlord. And that's the sort of the largest issue when it comes to commercial real estate. I mean, the best deals are when someone's buying the land and the business, but that rarely happens, especially in franchise deals. So, for example, you should be cognizant if you're acting for someone who's buying a business. And a lot of people use real estate agents, number one, to find commercial space and to find businesses that they can purchase. So, you should be aware when you're looking at the lease, how many years are left in the lease? Is there an option to renew? Right now, I'm dealing with a file where the lease only has 2 years with no option to renew. And, it's a laundromat. And the landlord is being difficult with the buyer. Well, if I'm a buyer, this is a business, I can find a laundromat anywhere where someone's gonna give me a 10-year lease and perhaps even pay for my water. So, Mr. Seller, you have a problem with your landlord, you need to figure it out. That's when we come to sort of asset purchases and leasing in that area.
Okay. And there's a combination, what Leon told you a while ago is with regards, for example, a Midas, right? You're buying the franchise together with the land. That is the asset purchase together with the commercial real estate. So basically, we're doing two aspects: the asset purchase, which is buying whatever the equipments on the Midas, including the franchise, and also with the commercial real estate because we're buying the land. That's the combination of both. I had one deal when I literally need to buy a land and the main tenant is just Starbucks. It's a big land in Hamilton and the main tenant is Starbucks. So basically, you need to deal with the seller's lawyer, with the franchisee's lawyer, with of course, with the previous, because we're going to be the new landlord right now, and we're going to be dealing with Starbucks as well. So there's all solicitors trying to close the deal. And of course, it's just weird that my client is a real estate agent as well who's buying that. So we work together with the contract because a couple of things that we need to review in order to assume that purchase, right? The lease pending with Starbucks. What are the restrictions for Starbucks? If he becomes the new landlord, what is he getting from that new lease, right? So let's move forward with commercial leases. Leon.
Oh, okay.
Yes.
I mean, on your end, you'll mainly be dealing with an OREA form offer to lease commercial space. And it might even be an asset purchase with commercial lease kind of thing. But the idea is in an offer to lease, you're setting up all the things that will follow in an official lease. And then that's what the lawyers argue with each other. One lawyer will say, well, my client thinks you need to take care of the HVAC system. And the other will say, well, that's on the offer to lease. And that becomes the big issue. So I think the idea is you need to have a condition that is very strong that says that an official lease will be completed within 10 days. And again, it depends on who your client is. If your client desperately needs this space, then you want to probably give them more time. If you're acting for the landlord who doesn't want to mess around, has an established commercial space and just has a unit that's for lease or whatever, you want to give them less time. Typically, these agreements always favor the landlord, as do commercial leases. It's not the same as residential tenancies. Commercial leasing is one of those areas where the landlord actually holds some strength in terms of dealing with people who've breached those leases. So go ahead.
Yeah, some of the commercial leases I found you can even use the OREA forms. They have their own standard forms.
Well, so the idea is typically you start with the OREA form.
Yeah.
And from there, that sets up the terms that are going to go into the official commercial lease.
Yes.
So that's why if you're using that OREA form, you need to make sure you have everything that's important to your client in that form. Signage is always something you need to talk about. Parking. And I mean, these are just the ones that are coming off the top of my head. There are several. You want to include a solicitor's condition. My lawyer gets to look at, your lawyer gets to look at this agreement specifically. You know, you need to consider purpose, use of the premises, hours of operation, and then very importantly, maintenance. A lot of landlords, again, depending on who you're working for. If you're working for the landlord, well, obviously, he wants a triple net lease. He pays for nothing. Everything goes under the TMI. But what happens in the event of an emergency? So your HVAC system has gone down. Who needs to pay to fix it? If you're acting for the lessor, you know, you want them to say the lessee fixes it and vice versa. So, you know, you have to pay attention to who you're working for, and you have to make sure your client has a lawyer available. Like, one of the problems I find is that 3 days before everything goes conditional, a client will ask, can you look at my lease and how much will it cost? Well, you've given me 3 days to look at it, and, you know, despite the fact that we're here, we're actually very busy, generally speaking. So that's not enough time. So if you're acting for anyone who's even buying, leasing, or being the lessee for commercial property, they need to have a lawyer literally at the same time that they're talking to you. Oh, the deal terms. Oh, well, since you've prepared this, why don't you go through it?
Okay, that's fine. With the deal terms, so as Leon said before, the first step is you need to settle the deal terms before negotiating the lease, right? You are the first contact with the client, so you need to understand what your client needs with the lease, right? If they're going to a premises, like for example with Remax, if they're leasing a particular office, are they doing the fixturing? Are they fixing it? Are they getting rid of the carpet? Of course, that's the time you need to negotiate with the landlord to have a fixturing period for how long? If you're doing a renovation for the what do you call that, offices. So if it's gonna be like 2 months, 3 months, usually in a fixturing period, that one is you're just basically paying TMI. The lease doesn't start yet, right? In Canada, convention is used to as a binding offer to lease, and it contains pertinent business terms that will reflect on the lease.
That's the order.
Yes. And what's signed, it is a binding deal. And of course, the lawyer, I have a client, I just recently reviewed a commercial lease. What they said, like, okay, this is a 6-page lease. Catherine, this is just, we don't need a lawyer to review this one. It's a 6-page lease, right? Because usually that's when we go to the lawyer, that's the time when there's a 40, 60-page commercial lease, because that one is more thorough. I told the client it doesn't make sense, because when you sign an offer to lease, basically the terms, the pertinent terms on your lease is there. So might as well, whether it's a 6-page lease, a 10-page lease, 40 or 60-page lease, it's a very important condition, as Leon said, that a solicitor needs to review. So that in a way, the realtor who prepared or whatever the draft, or who drafted the OREA form for the offer to lease is protected as well. And your client is protected as well when you get yourself binded in a lease, right?
You know, I think it might be important to mention as well, at the time that you're looking at a lease, again, if you're acting for the lessor, I mean, perhaps if you're acting for the lessee, but even if you're acting for the lessor, you should have drawings of the building available, or they should have drawings of the building available. They should have a sketch of the space that your client is either renting or leasing, because all of those things go into the lease so that there's a certain amount of specificity as to what the person is getting.
Okay.
It's kind of like a survey in residential, which you don't always have, right? So that's a part of the agreement. If it's not available, you need to talk to your clients about whether they can get it available if they're the lessor, and if you're the lessee, you have to make sure you ask for it.
Yeah. Okay, and couple of points with regards to the lease. Usually if it's very long, it's not tenant friendly, it's more landlord. A lot of things are conditions for the landlord, in favor of the landlord. Landlord will provide tenant with his form of lease to be amended. Of course, as soon as the lease is signed, it's hard to be negotiated, right? And it's hard to break the terms once you've signed that contract. Okay, now let's go to the important part when you do the drafting. right? A lot. Actually, when I was talking to Vahisan, he was telling me, Catherine, like, is there a certain like clauses, like particular clauses that we need to add when we're doing an offer for the for a commercial property, right? Or if you're doing commercial and asset purchase. The first thing that I will tell you first is there's not the first clause that you need to look at is a standard due diligence, right? And you need to understand what your client is buying. So the three important things that you need to put in the OREA form are the three things: building and zoning report, tax, and water. Those three are the basic due diligence that you need to put. Let me give you an example for building and zoning. Is anybody aware of the grandfather rule? Like with the municipality? Okay. I've encountered a lot of things. When my client is buying a property, they're going to tell me like, okay, Catherine, I plan to develop this one as an industrial one because that's the previous use of the seller. Okay. Seldom does people know zoning changes all the time, right? If the seller can use it for a particular use, it doesn't mean that your client can use it for the same purpose. Because once the zoning change, your client is going to be stuck on a property thinking that he can use it as the same purpose of whatever the seller is. So
if you have the grandfather rule, once the sale is happened, it's closed, then it changes, right?
yes, the grandfather rule means, what does it mean? It means the grandfather rule, that zoning is only applies to a particular owner. The owner, the current owner of the property. So if the seller is using it, for example, as a restaurant, and during that time, there was a change of the rules. Of course, the city cannot kick them out and change the zoning on them. It's particular only to the seller. It doesn't mean that the old zoning is particular to the new buyer, right? When they had it rezoned and different with different zoning classification, it doesn't mean that the buyer can use it as a restaurant as well. So be very careful with that. Okay. And I have a couple of deals telling me that, okay, Catherine, can we close this one in 5 days? Right. They signed 5 days. I said, how can you close a commercial deal in 5 days? Even residential, they need 30, 60, 90 days. How are you going to be able to do your due diligence? In order to get building and zoning report, usually it takes 10 to 15 days, business days from the city, right? And second, tax water certificate, 10 business days. How can you be able to firm up your deal knowing that your client cannot use it on a particular purpose? So what I usually suggest, if you guys agents are not so sure what particular searches that needed to be done, at least put a clause. It's conditional upon the buyer's 30 to 60 days due diligence. If the buyer is not satisfied with their due diligence, then it gives the buyer the right to get out of the contract. If you cannot pinpoint particular ones. Usually we have agents like Catherine, I'm buying a restaurant. What is the most important thing that I need to look for? Of course, besides the basic three, you need to look at, is it a fire code? Like if it is fire code compliance, are they selling liquor? Are they assigning a liquor license on that, right? Couple of things that you need to consider. Does the building have an elevating device? Then of course you need to have the TSSA, right? Is your client obtaining financing? If your client is obtaining financing in a commercial property, this one is not like a regular bank. The regular bank doesn't need, for residential, they don't need environmental inspection. For commercial property, it's one of the requirements of the bank.
Well, and there's always guarantees and PPSAs, and it's never, so most people think they can manage their commercial loans with the bank by themselves and not engage the lawyer because they think it's gonna save them money. And then a week before closing, all of a sudden the lawyer gets information that there's a commercial loan happening and they need to have these minute books ready. They have to be able to show resolutions, shareholders registers, all these things. And half the time I find these people have created their corporations online by themselves or their accountant did it. All they have is articles of incorporation. And literally, it's a week before closing. And then if there are several shareholders, it becomes even uglier. No shareholders agreement, nothing on the corporate side. And then they'll be like, oh my God, but the bank always told me this was very simple. It would be easy. And then what usually delays these deals? Finance, mainly on the commercial side.
Yes, so I don't usually suggest every time I see a deal, like they're scheduling their closing date 2 weeks, a month for a commercial closing, especially $1 million property. I always tell the agents or I tell the clients, do you think you can able to do financing with just a couple of months or a couple of days? No, it's not like residential that you can do a rush deal, right? You cannot. For commercial, you need to sit down because you're buying a big property, right? It's not like a cheap ones that you can easily dispose. This one is commercial, a bunch of things, a lot of requirements from the bank. It's not a simple financing. It's good if my client is buying cash, but who will buy now a cash for 10 million, $20 million property, right? It doesn't happen that way. So usually we engage through, because when we do financing, for example, even though it's a bank, in a regular real estate deal, we just deal with the bank directly. When we deal with a commercial, the bank will be retaining their own solicitor that we will be satisfying all their terms and conditions in order to close the deal. And you need to understand what your client is buying. And if you're not sure, we'll be happy. As solicitors, I've worked a lot with agents who's asking like, Catherine, can you just look at the draft agreement of purchase and sale? Is there anything else that you felt that we need to add to protect my clients? Like adding conditional period, adding additional searches, adding additional due diligence for the property, right? To make sure that they're happy with the purchase as well, right? Okay, next one, the use of the property. So once the client has satisfied himself that he can use the property as a commercial and receive, of course, satisfactory confirmation, the projected use for the property of the buyer. So then we get a confirmation from the city that they're allowed to move forward with whatever they're intended to do with the business, right? Whatever they're buying. And of course, we're thinking like, okay, if it's a commercial property, I've seen OREA forms. I'll be honest with you. I've been seeing OREA forms that the agents have been using for a commercial, which is a residential OREA form. They put HSTs included in the purchase price.
But
I've
that's what
seen,
we're gonna do.
yes, I've seen,
Forms, you're not gonna use a residential for a commercial.
yes,
But the important point here is that you have to remember, if you're acting for the seller, you want HST to not be included. And if you're acting for the buyer, you want it to be included. And then one of the things you might wanna ask your client, most people don't, and then this becomes a panic item, because, you know, if one corporation buys commercial property for another corporation, HST is often exempt if they both have HST numbers. But you'll ask your client, do you have an HST? Well, no, you don't. Real estate agents never ask their clients if they have an HST number. Ask. It makes everybody's life easier, because if they say, I don't know, then the answer is call your accountant, get that HST number, and if you don't have it, call CRA or have your accountant call CRA and get that HST number.
Yeah.
Right? And in your agreement, you're going to include certain documents that you want to be provided upon closing. One of those things will be an HST declaration saying we have the seller, or the, you know, if you're acting for the buyer, the seller has an HST number. So that if you have an HST number, again, HST becomes much less of an issue. Right? So on your side of things, the most important thing is just to ask, do you have an HST number? Or does your corporation have an HST number? Yes, sir.
Does the HST number exempt the purchaser from paying the HST?
It doesn't exempt it, it
Offset.
postpones it,
yes.
right? So eventually, somebody's gonna pay HST,
Yeah,
but who knows when that will be? As long as everybody has an HST number, HST isn't payable on the transaction. You're just postponing it to the person who buys it from your client. Let's say your client is the buyer.
yeah.
Everybody has an HST number. You're postponing any HST payment to the next person.
The next buyer?
Yeah,
Okay. That's why,
and then, but if they have an HST number, then it gets postponed again. Like this can be postponed into perpetuity, right? Until at some point, somebody doesn't have a lawyer smart enough or doesn't have a clue about HST and buys it without an HST number. And that's when the taxman will come to you, the seller, and say, oh, you were supposed to collect HST and you're required to pay HST. So remember, it's never the buyer that's on the hook unless the agreement says different. But again, I will tell you this much as well. CRA doesn't care about your ORIA agreement. So while it's important to make sure you look at that clause about HST, I believe it's page 2 of the agreement, and decide whether it's included or not, it's even more important to make sure everyone has an HST number. Right, because at the end of the day, the seller is always, the vendor, for CRA purposes, is always responsible for the collection and remittance of HST. The only way you avoid it is by filing I think it's a T-2057, both parties fill it out, they include the information, and now nobody has to collect or remit. And you can keep doing that. I've bought and sold the same business 4 or 5 times. Again, mostly laundromats for some reason, I don't know, but mostly laundromats. But you just keep passing it on.
What if we buy the corporation also when we buy the business?
So it depends on how you're buying the corporation. If you're buying the assets or the shares, you have 2 completely different scenarios.
Are we taking over the business and with the corporation?
Well, but that's what I mean. You're either taking the business over by, if it's a corporation,
Yes.
you're either buying the shares or you're buying the assets.
It's not buying the whole.
If you're acting for the buyer, you don't want to buy the shares. You absolutely don't want to buy the shares because the shares exist in perpetuity. And whoever the shareholder is, they're responsible for everything that happened in the company. If they didn't file taxes, if they filed incorrect taxes, if they owe money, if you're the shareholder within the 7 years that you bought it, and CRA comes back and does an audit of this corporation, you're on the hook.
But
So
isn't it when we buy the things that day is we are responsible for the corporation?
no, the shareholders are always from day one, you're responsible. Your agreement might say that the seller will indemnify you,
Yes.
but you know what? Again, CRA doesn't care about your agreement. You can take the seller to court, say you indemnified me, but if the seller has long fled the country or the company's been dissolved.
But we did with the affidavit with the lawyer on that period, from whatever happened before that period, that is their responsibility. And we taking over this day, we are the
Well,
responsibility.
but again, that's what the agreement says.
Yes,
CRA doesn't care.
but when we have it with the lawyer's agreement with it.
It doesn't matter. CRA doesn't care. Now your lawyer's gonna say to you,
Corporation is still responsible.
Yeah,
The
so-
CEO owned the corporation now, the CRA is going after corporation, just because CEO owned it before.
Yeah,
They can't go.
you're
after-
still, all your lawyer's gonna tell you is, if he's sort of a.
Always we recommend not to buy the shares because it's always a problem.
So if you cannot, so remember that
That's
the buyer, remember that the buyer also
I
wants to
agree.
sell shares for a tax reason, right?
Yeah.
If you're the seller, you can take advantage, if you sell shares of a closely held private corporation, you can take advantage of a capital gains discount, which has changed somewhat now, but there's an exemption that still exists. That your first $900,000 is exempt from capital gains tax, which is a lot considering what capital gains tax is now. So if you own a business that's worth $1 million, and you obviously want that other person to buy your shares, because basically you're selling it for $1 million almost tax free. But the buyer is taking on all the liability, could be held responsible. And again, if you have a good lawyer, your agreement will say that they will indemnify you and they'll cover you for all of this. But today, in our court system, as unfortunate as it is, if you bring a civil claim, it will take you 2 to 3 years to see it wind its way through the courts. And it will probably cost you, even if you're awarded costs, rarely do people get the full costs involved. The litigation lawyer that we refer to is a really good lawyer that gives our clients a discount, but he starts off with a $2,500 retainer.
And $600 an hour.
And usually, yes, I'm not.
That's
yes.
true.
Yes, I wish I was him, but I'm not. And so you're better off making sure that you use someone like me to make sure you don't get them there.
I have one classic example because I have a client who came in. For some reason, he did a share purchase of a corporation. They never receive any consideration because the corporation owns a property, right? We're in the process of transferring now. He said, Catherine, since I am the sole shareholder of the corporation, I'm going to be transferring the property from the corporation to my name because he needs to use it for some other purposes. Lo and behold, when I pulled the parcel, there was a tax lien on the property from the CRA worth 300,000. Okay, immediately what I ask, did you do your due diligence with regards to the corporation when you bought their shares? Because immediately your due diligence is you wanted to make sure that their filings are up to date, their tax are paid and up to date. Oh, he said, oh, it's my lawyer who handled this from the very beginning. My lawyer never told me. I said, that's the first thing that the lawyer will tell you because a CRA is a super priority lien and they can register against the assets of the
I
corporation.
have a very good experience with that kind of liabilities.
Mhm.
Recently, last year, one of my client paid almost $480,000 a lien against their house. He didn't even know he was on a corporation. The lien came from CRA to.
Sure, and now he's probably selling the sewer.
Yeah.
And he's probably already given his lawyer $20,000.
Yeah.
And his lawyer is telling him, don't worry, we'll update you when we get a court date. And then every 2 months he gets a bill, $600
So what
for
happened is-
monitoring the file.
What happened? He didn't file his taxes, T2 returns for years and years.
Yeah,
And he didn't even get the letters because it was associated with another address.
yeah.
And
And
finally got a lien against the house.
And it's so funny, he paid like 300 to 400,000 to acquire those shares. And he realized that there was a 400,000 tax arrears on that corporation. So you took over a corporation who is in debt, right? And not a good debt. It's a CRA debt. They think they can get around with it. So now, to make the long story short, he cannot even touch the property. I said, as much as I want to transfer the property, because there's no mortgage on the property, he's very proud. You obtain a corporation who owns a property without even have a single mortgage on title. Of course, they registered the tax lien after he purchased the property, the share, sorry.
The PPSA, right?
No,
No. because
no,
this- A tax lien is just, you
different.
owe taxes, they get to, it's a super priority. They just register if you don't return their calls. So again, I sold this business and CRA is calling me. I'm like, I'm not answering the phone. It's not my problem,
They
right?
register
And
the
it's not-
lien after they get the judgment from the court,
Yeah,
right? So.
yeah,
But
that
when you
one.
check on I don't think the corporation will check by PPSA or by.
PPSA cannot be,
No,
a
that's
tax lien cannot be checked
PPSA
by
tax.
PPSA. A PPSA is, for example, a classic example of a PPSA is when you buy a car. It's if you get financing for the car, that's a PPSA
Let's give
lien.
you a better example.
Even
If
the-
you're buying a business that has equipment,
Yes,
right? And you're borrowing money to buy that business. Maybe it's a pizza shop, maybe it's whatever. You know, the bank will put a lien on all the physical assets. And in some instances, if you're actually borrowing money or doing some sort of leasing arrangements to buy the equipment, the lessor will put a PPSA registration. But CRA is not like any of these things.
yes,
Right? CRA, like she mentioned, default judgment. CRA doesn't need a default judgment. First they'll freeze your accounts. If they still don't hear from you, they'll look for any property that the corporation or you own and they will put a lien on it. And, you know, the only way to remove it is to pay them off. They are a super.
Where do we check it out?
Where do you check it out? You do a tax search. You do a
yes.
tax search.
Yes, you need to verify if there's any outstanding and they need to give you proof that everything has been paid and up to date.
And remember, most tax searches take a week, which brings me back to,
Yes.
you know, we're not gonna call a lawyer till 3 days before closing or 4 days before closing. You know, what we do is we actually get them to sign a letter saying, you haven't given us enough time to do full due diligence, and we recommend that you do this, this, and this, and this. And because there hasn't been time, generally we suggest an extension, if that's not, and again, markets dictate these things as well, right? If it's a bad market, extension might be easier. If it's a hot market, maybe not as much. It depends on the type of business, etc. But again, I mean, nobody buys something and sets a 2-week closing date unless it's non-arm's length or there's something
But if the.
different going
If
on.
the seller doesn't give you the permission to, give the personal information.
No, well, that's part of your agreement, right? That they'll give you permission to get the information. That's your due diligence clause that she was talking about. Why would you leave that out?
Yes. Especially for commercial properties, these are very crucial. You don't omit that one, making it a firm deal. So you still need to do your home inspection. As lawyers, we need to pull the PPSA, make sure that we write to the proper agencies if there's any for taxes, if there's any health issues, health compliance that needed to be done. Right? And of course, the last part is the HST as well, that I want the agents to be aware that in every commercial deals, there's always an HST involved. So we need them, the clients, both the seller and buyers, to be HST registrants. Okay. Sometimes we have questions like, okay, at that time when my buyer is buying the property, they didn't incorporate yet the corporation, right? So it's gonna be like in the name, in trust for a company to be incorporated. I think a bunch of agents have been doing that, right? I would suggest once you do that, I want you to speak with your lawyer or with your accountant because you need to incorporate as soon as possible. And of course, you need to have an applicable clause that the seller agrees that you're going to be changing the buyer to a named corporation, a numbered or a named corporation. And the next step is you need to have an HST on this transaction.
So for that, on some level, I actually say you should talk to your accountant even before your lawyer. But if your accountant says he's going to create a corporation for you, say, no. I'm going to let my lawyer create the corporation. You're an accountant. The lawyer's going to create the corporation. Too many times I've seen people who've let their accountant create their corporation, and it's just because it's not what they do. And they just do it because anybody can go online and create their own corporation. Doesn't mean anybody should do it. And inevitably, I'll get a call, or I get a lot of calls from people who created a corporation either themselves or through their accountant. And now we have to go back and create legal records for the corporation from 5 years ago, 10 years ago.
You have to prepare the minutes and all.
Yeah, so what would have cost you $800 at the outset, and by the way, your accountant probably charged you $200 or $300, is now going to cost you probably $2,000 to $3,000 because we're basically creating the history of the company, right? So that's just a tip that I like to bring up because as technology improves, more and more people are giving opportunities to do things on their own. So it used to be people doing it with accountants. Now there's a couple of apps. There's one in primarily, go ahead.
I was gonna say, what are your thoughts on owner?
I hate owner, and I'm gonna be straight with you. I have another slide point presentation that shows you the terms and conditions of owner. So let me tell you a few things about owner. Let me tell you the thing that I find the worst. Owner is 20% owned by Royal Bank of Canada. Do you think that owner is not sharing your information with Royal Bank of Canada? And then ask yourself, do you want Royal Bank of Canada to have that information? That's all private information. The banks are the largest information gatherers in this country, and they don't use it for anything that's beneficial to you. So that's number one about owner. Number two, in their terms and conditions, they tell you very specifically, we are not lawyers, and you are not engaging in a lawyer, and you cannot come back to us and say, I thought I was getting legal advice. When you engage me to help you with this corporation, I'm not saying that. I'm saying, oh, I know what I'm doing. I've been doing it for 25 years. I am a fully licensed and registered lawyer. And by the way, I'm also insured in case, in the slight instance that I may have been off on that day and made a mistake, I'm also insured. And again, owner also is not even cheaper than us. At the end of the day, you're going to pay as much as you pay with us because they will charge you. They'll tell you, you should store your records with us, make it easier for you every year going forward. I think that used to cost about $50 a year, $100 a year. Think about it. A corporation is like a person. It's going to live as long as you do until you die. So if you have this corporation for 20 years, you're paying $1,000 just for storage. We don't, I think they even charge more. And yeah, And so, my numbers are off because no one's asked me about this in a while, but it's definitely a pet peeve. Don't even get me talking about willful. People should not do their wills with willful. Again, these apps, I love technology. Technology is fantastic. Technology in 2024 is not meant for our benefit, right? It's for the benefit of those that invent the technology, own all the shares of these companies, the Bill Gates and everybody else in the world. But we're getting off topic now. But yeah, don't use owner. Don't use.
Yes. So basically, to sum it up, these are the important points. And do you have questions though for us?
How many days we supposed to put the condition for lawyer to review? 30?
For lawyers, usually due diligence for the client 30 to 60 days and give us 10 days to review.
And commercial also varies. I'm going to combine commercial with developmental as well, because it's sort of the same collective. If you're looking at a property that's going to be developed for industrial, whatever, you want a due diligence period. Like what a lot of people do is say, 30 days, closing will be 30 days from completion from our due diligence, which will take no longer than 6 months, as long as the seller is cooperative in providing documents and perhaps assisting in any applications that need to be made in terms of the property. Like, I think you guys will also encounter a lot of people that are looking at developmental property, which is, a lot of it is very similar. Same type of due diligence, same type of time period that you're looking at. But for development, you probably want even longer than existing commercial property.
So I know from your firm, you guys go through the full agreement inside out with the lease agreements, especially with the long form. You
Yes.
read it through everything, or you just glance it?
We always read everything because the fine print are the scariest ones, especially with builders too. Those are the fine print. The one that you wouldn't read, that's the one that's deadly in the contract.
So we came across a lot of issues with the legal part of the purchase and sale agreements. Right? Sometimes even the lawyers, they don't go through the agreement in full. We find problems when it comes to closing, right? That is the reason I'm asking.
I'm happy to talk badly about owner and willful and that stuff, but other lawyers, I can't speak for what they do, and I generally avoid speaking ill of other lawyers. A lot of lawyers are very busy. They don't have resources. We didn't include it in this presentation because we thought we had less time than we do, but we're a team of 10 people. We have several people in several roles. We've got 6 clerks. So everything gets looked at top to bottom. The whole idea is that, our lawyers, Kathy and I, are not swamped doing small stuff all day long, so we can read the agreement from top to bottom. And listen, I'm not going to lie as well. There's a lot of what we call boilerplate language in most leases, the kind of stuff you'll find in any good lease. So if I come across that clause, like governing law, well, it takes me 5 seconds to look at the governing law clause and say, it says Ontario and Superior Courts are Ontario, and boom, we're done, right? Successors and assignees, that kind of thing. You want to make sure that that stuff is getting looked at, but also you want to be confident that the lawyer you're working with is looking at the important stuff. TMI, what am I responsible to pay for? What's the term of the lease? Are there options to renew? What if I need to get out or sublet?
Yes.
Right? Those are, we didn't talk about sublet or any of those things, but and also, we didn't mention this, commercial leases, personal guarantees. I'm pretty sure I don't have to tell you this, but every landlord wants a personal guarantee and every tenant does not want to give a personal guarantee. So when you're talking to your clients, you need to prepare them, especially if it's a tenant that has a business that doesn't have a long operating history, right? The landlord's gonna be like, well, good for you, you have a corporation and but I know that I need a personal guarantee to know that I'm gonna get paid. So those are things that need to be looked at as well. Personal guarantees, to me, I do these types of sessions for new business people, starting new small businesses or tech businesses. And that's why I tell them long-term commitments. Typically, your lease is a long-term commitment. So your client, again, if you're acting for the landlord, they know what they have, they know what they're doing, they want a long-term commitment. If you're acting for someone who's just starting a business or whatever, again, franchise is accepted, and that's a very complicated commercial lease environment.
Mhm.
But otherwise, you want to talk to your client and make sure that they realize that they're probably going to get asked for a personal guarantee. So is your credit rating decent? And are you willing to make this commitment, knowing that, you're starting something new, kind of thing?
But they can go against your personal property.
Yeah, absolutely.
Yeah.
That's what they'll register against you. If you're giving a personal guarantee, they will register your name. They'll register your name and your birth date, and you're responsible for whatever is owed on that commitment.
Isn't it, you can do by some 3 months or 6 months payment or something?
Sorry, say that again?
3 months or 6 months monthly payment or something, we can.
It depends on the landlord.
No, that is depends on the lease agreement.
Yeah,
Yeah.
Yeah,
it
yeah.
depends on the landlord, yeah, on the lease agreement. Whatever you sign up for, yeah.
Most of these commercial leases are also has a personal guarantee on it, right?
Majority, yes.
That all depends. I will say, like I tell my clients who are gonna be tenants, if they don't ask for it. So here's where the offer to lease comes in, right? If that offer to lease, if you're acting for the one person who's gonna be the tenant, and whoever prepared it didn't include a section that says personal guarantee to be provided, right? Then when it gets time to prepare the official lease, if it's not there, then the landlord's lawyer is gonna have a hard time. Now, again, it's a matter of relative positions of power. Because most often the landlord will say, fine, then we have no lease and you can't have the space. And that's obviously a difficult position to negotiate from. They'd rather make sure that their tenant has given proper guarantees. But still, it's all part of the negotiation. So like when we quote a client to review a lease or something like that, our quote is generally bakes in the idea that there's going to be some negotiation involving certain things, right? So that's that's usually one of the bigger ones.
If it is, my property is in a family trust, can I be able to come as a personal without my property?
Well, you mean property that you're leasing?
No. See, if my property is in family trust, right? So if I even say I give a personal guarantee on the commercial lease.
No. So the family trust means I don't know if you've already created a family trust, but if you haven't, if it's been created properly, then no, they won't come after you.
That's all. We have.
They can't. Pardon?
Sorry, yeah,
How
go ahead.
about sublease, like when you are leasing it from the bigger owner for a smaller.
Again,
space?
that's a subject to be negotiated.
Yes, as well. Yeah, because it needs to be open too, that you have, when the lawyers look at your lease, right? We wanted to make sure that you have a way out. So what is that? Assignment, subleasing, right? Just in case, like for example, who can predict if the business will be profitable in a number of years? If you realize in 3 years, no, the business is not working, but you still have an obligation with the lease. You still have 2 years. You have the right to sublease or to assign the lease, whatever you have. So at least we're making that options for you, just in case that you have a way out of the
So
lease.
for all these things, over the years, clauses that sort of accommodate both sides have been developed, right? So for something like assignment and subletting, you'll usually see something that says, tenant not allowed to assign or sublet the lease
Without,
unless they obtain the consent of the landlord in advance, and then such consent not to be unreasonably withheld. Right? So that satisfies everybody. If you want to sublease it and you have a legitimate tenant that the landlord, after they do their due diligence, which will likely involve credit checks and the signature of a proper assignment of lease agreement, then the argument favors the person trying to assign or sublease.
But the lessee has a problem with the landlord and then subleaser, like let's say my client is a sublease guy.
Mhm.
So it is going to impact him directly, let's say the main tenant is.
Yeah, most assignments include provisions that say the original
Contract.
lessee is responsible.
Yes. And it's bound by
So
they're
that's why
bound by the
it's
original
important for
contract.
both parties to make sure that they're, subletting or assigning to a responsible, legitimate third party.
You have any other questions? think we're good.
Excellent.
Thank you
Lisa's
so
gonna be here.
much. Thank you, Leon. Thank you, Catherine.
You're very welcome.
I have this, if you don't mind, I can share this with them.
Stay in the room.
Yeah, we'll take pictures first.
Yeah, let's take a couple pictures first. That'd be nice.
First thing to go.
Sorry?
Yes, sorry. Do you need anything?
Yeah. I'll stop this recording.
Oh, prices for what?
Legal fees, that's what they ask.
For what? Because,
Thank you, everyone online.
So, let's say,
See you.
review a lease agreement.
For the
oh,
lease,
for the review, the lease agreement, the baseline is $395,
Okay.
right? It will go from there, how difficult